life is so unpredictable. You never know how things are going to unfold. At least I never have. And if you had told me when I was in law school, let's say, that 50 something years later, I'd be not only still involved with military law, but would have been involved basically for half a century in military law, I would have said, you're out of your squash. This is not, that's ridiculous. By way of background, one of my proudest possessions is, and about the only thing I inherited from my grandparents, was a certificate that was handed to me after my uncle died. It was a document he'd had in his papers, and I opened it. It was all folded up and held together with yellow Scotch tape, and I had no idea what it was, except it was in Russian. And I found a Russian speaker, reader at Yale, who explained to me that this was my grandfather's draft notice from the Tsar. I of course, treasure it. In the end, he didn't have the opportunity to serve the Tsar. Instead, he went across the border and wound up in New York and lived happily ever after. But so even from an early stage, the family had a sort of odd military connection. My father served for some unknown period of time in the New York National Guard. The only thing he ever told me about it was that he marched in President Roosevelt's inaugural parade when he became governor of New York in, I think, 1929 or 30, something like that. So it was a kind of odd that I wound up not only going in as many men had to during the conscription era, but wound up having really a very positive experience in uniform. I served for 3 years, 7 months, and 8 days. I went to Coast Guard Officer Candidate School. I later went to the Naval Justice School. I served in Boston, Los Angeles for a little while, and at Coast Guard headquarters for a year. And then I found that it influenced the entire rest of my career. For most of my law practice, I was doing federal administrative law at the old LaBeouf law firm of blessed memory. And then at the firm I'm currently affiliated with, Feldesman Tucker, which is a wonderful firm. And it's, but yet the military work has been a continuing theme for me and a source of great pleasure, gratification, satisfaction, and challenge. I'll make a few comments about sort of current developments that people might want to be interested in, and then I'd like to open the floor for Q&A as much as possible. And if people are dying to raise a question, I don't mind being interrupted. That's easy enough. First of all, so how are things doing in the military justice business? The answer is they're okay, they're interesting, there are challenges. Interestingly, this year is the 100th anniversary of the end of the so-called Ansel-Crowder controversy, which took place between 1917 and 1920, between two Army generals, one of whom was very reform-oriented and the other was not. Crowder was the non-reformer, Ansel was the reformer, and history has been kind to General Ansel. I'm happy to say that as it happens on Pearl Harbor Day, I'm going to be hosting a Zoom session under the auspices of the Global Military Justice Reform blog that I edit on the occasion of the centenary of the Ansel-Crowder controversy. But anyway, Uh, the first thing to know about the military justice system right now is cases are way down. The caseload is, it's over 1,000 cases a year of general and special courts martial and a smattering of summary courts. So trials are way down. The trials that are conducted are often uncontested, a lot of guilty pleas. A remarkable number involve sex offenses. There's a lot of Article 15s, non-judicial punishment, masked office hours, you know it by all those terms. Something like 100,000 of those per year, which is interesting in itself. I should mention this. There are three areas that are really understudied. One is non-judicial punishment, because it can have devastating effects on the person's career. And people now are in it for a career typically, or they like to make it a career. It's not a conscription environment. The second is professional responsibility issues. What can lawyers do and not do? It's a very understudied area. And the third is corrections. And I don't mean corrections of records. I mean, what happens to the people that actually get convicted and sent to jail? Very, very little is known about how the military correctional system functions. It's outside the ken of the military appellate courts, and the civilian courts basically have a hands-off attitude. Unless there's a death sentence, then they get interested, sort of. So those are areas that are worthy of study that they haven't gotten. As far as the appellate courts are concerned, the Court of Appeals for the Armed Forces, which some of us remember as the Court of Military Appeals, or COMA, as it was called, it now has more judges and fewer cases. Until the 80s, there were only 3 judges, which made its jurisprudence kind of tippy and easy to change. Now it has 5. But the caseload is way down. In the term that just ended, the Court of Appeals decided only 25 cases on full opinion. They reviewed hundreds of records, often in cases where nobody could identify an issue. But only 25 cases involved oral argument and full briefing and a published decision on the merits. The court's budget is something like $14 million. And it's obviously not fair to simply do the division and say, well, that comes out to several $100,000 per opinion. That's silly. But the fact is, it's a pretty costly enterprise for a fairly modest output. The other thing that's interesting, and I'll mention that when I teach military justice, which I've done for the last 11 years at Yale and now at NYU, and in the spring I'll do it at Berkeley via Zoom, I have my students for the first session pick a Court of Appeals for the Armed Forces decision at random from the last term, and come to the first class prepared to address whether you need a specialized appellate court to decide that case. Just how arcane is this subject matter? And the fact is that nearly all of the cases that the Court of Appeals decides are cases that could just as well be decided by a panel of the DC Circuit with proper briefing and argument by people who are familiar with the record and the applicable law. When you think of the things that the DC Circuit decides coming from the Federal Energy Regulatory Commission or the SEC or the FCC that are far more arcane, or at least equally arcane, it does seem a fair question whether 50 years on, or now 70 years on, there continues to be a need for a specialized appellate court. So I'll just throw that question out there. A current issue, and it's a major issue, is has the time come to take the so-called disposition power, that is, who gets tried for what, out of the hands of line commanders and put it in the hands of lawyers outside the chain of command. That's the way events have unfolded in the UK, even though our system is modeled on George III's system. The UK some years ago gave the charging power to lawyers outside the chain of command. Ditto for Canada, Ireland, New Zealand, Australia, Israel, South Africa, and other countries as well. And of course, the Northern European countries have basically zeroed out their military justice systems. In Holland, for example, they try GIs in the district court in Arnhem, and they put an officer on the court, and there's a little military prosecution shop there that handles whatever they have to handle. But basically, it's integrated into the civilian system. In Germany, crimes by members of the Bundeswehr are prosecuted in the civilian courts by civilian prosecutors. And what we think of as military justice matters, disobedience, disrespect, shoeshine issues, are handled administratively, and that's that. Events have unfolded, and our system is what in Europe would be called a non-compliant system. Non-compliant means it wouldn't meet the standards of the European Convention on Human Rights because it lacks the independence from command that the court in Strasbourg has required. And that jurisprudence has been influential around the world, even in countries that do not subscribe to the European Convention on Human Rights. An important issue that's been on my own mind is access to the US Supreme Court. Until 1980, until the 83 Act, which took effect in 84, a GI couldn't get directly from the highest military court to the US Supreme Court. He or she would have to start again by habeas or an action for back pay or something like that, and then work it up through the Article 3 courts back up to the Supreme Court. And occasionally military cases went up there. And in fact, some very major cases, the cases from the 50s that we're all familiar with, Toth against Quarles, for example, or Reed versus Covert. So in 1983, Congress changed the statute for the first time to give the Supreme Court direct certiorari review of decisions of the then Court of Military Appeals, now the Court of Appeals for the Armed Forces. There's only one problem. When Congress did that, they were concerned about unduly increasing the workload of the Supreme Court. So they limited the certiorari jurisdiction to cases in which the Court of Military Appeals had granted discretionary review. So you had, and of course, most of the cases, the Court of Appeals denies discretionary review. The net effect of that is that to this day, 9 out of 10 courts-martial, generals and specials, are never eligible for review by an Article 3 life tenure court of any kind. The only way a GI whose case has been denied discretionary review by the Court of Appeals for the Armed Forces can get in front of an Article 3 judge and up to the Supreme Court is by starting again in a habeas or a federal question case in the district court somewhere. Well, you might say, okay, so what? And the answer to that is a couple of things. First, why should GIs have less access to the US Supreme Court than, for example, the people being tried at Guantanamo by the military commissions? Why should GIs have less access to the Supreme Court than anybody tried for a minor offense in the District of Columbia, or anybody tried in a federal court for a fishing violation or littering in a national park? That's one level of the problem. The other level is it's not a good substitute to say, well, try it in habeas corpus. Why is that? Because habeas review is much narrower than direct appellate review, famously so. And the test for habeas in military cases is basically, if the military system has given you a full and fair hearing, that's it. It's game over. You're just not going to get any traction. So that's a serious problem which Congress has been aware of, but who lobbies Congress to fix something like that? It's a million different things that take greater priority. So that's a frustration. An interesting issue that people on this call may remember. Anybody remember the great case of O'Callaghan against Parker from 1969, where Justice Douglas got a majority for the proposition that courts-martial could only try cases that were service-connected? Does this ring a bell? That was later overturned by the Supreme Court in a case called Solorio against the United States. And there the court held that so long as the accused was a member of the service and subject to the code, any offense was within the court's subject matter jurisdiction. At least it was not constitutionally required that there be a service connection, just to be a little lawyer-like about it. So we are now left with the following situation. From time to time, cases that really have no service connection do wander into the military justice system. And I'll give you a current case. I read about it the other day. A Marine is under charges, I think at Quantico, for a murder, at least the charge is murder, a homicide that occurred in Brighton, Massachusetts. Apparently it was a street fight outside a bar in Brighton. And stones and bricks were thrown, and some guy got killed. Oh. A grand jury in Suffolk County, Boston, refused to indict. And for some reason, the Marine Corps decided that, probably pressured by the family of the victim, the Marine Corps decided to prosecute this Marine in a general court-martial. And, I'll just raise with you the question, is that a proper use of the military justice system to sort of second guess the civilian authorities over what's obviously a civilian offense? I mean, no connection other than the line of work that the suspect is involved in with the military. So that's a sort of lingering issue. And finally, let me just flag, and then I think after this, let me open the floor. I'll flag questions that have arisen in the last year or two regarding pardons that have been given to people convicted of or under charges relating to war crimes. I don't want to argue those cases. I'll simply say that, and everybody I think is aware that the president has any president has extremely broad powers, total powers, to grant pardons. It's a core presidential function. That said, there is an issue as to whether it is in itself a war crime to give a pardon to somebody who's been convicted of a war crime. This is the doctrine of command responsibility, which, if you remember the cases that arose at the end of World War II, there was a Japanese general whom we hanged on the theory that he was responsible for a rampage that his troops committed in Manila in 1945. This is General Yamashita. It's a famous case. And that was an example of this doctrine of command responsibility, that a commander has a responsibility to keep his troops orderly and to punish those that are not orderly. And no cases have litigated this, but because there's no record really of people holding clemency power in any country, using it for the benefit of individual soldiers who have been convicted of war crimes. So this is an emerging issue. The scholars who follow the law of war, law of armed conflict, have been thinking about it. There'll probably be some law review articles written about this. But it's another current issue. So I've put a whole lot of things out there on the table. This would probably be a good point to open the floor if anybody has any questions.
So we have a few that have come through.
I've got a couple, actually.
Good. Okay.
So
Well,
I guess
hold on one second. I want to get to the ones that have been submitted in the chat first, because I don't, just to keep things a little orderly. There's a couple about specifically about sexual assault cases, and should they be removed from the normal chain of command? Yeah.
Well, okay. Just a word about that. It's quite interesting. The last few years, attention has been riveted, properly so, on what seems to be an intractable problem of sexual assault in the military. The services, with the integration, increasing integration of the military in terms of gender, and there are many women on active duty in virtually every MOS. And this has presented a challenge to military leadership. I believe claims, some of the claims at least, about whether there's an epidemic may be overstated, but I have no doubt that there's more sexual assault and sexual harassment in the military than any of us wants to see. People are there voluntarily. They deserve comradeship rather than hostility and harassment, and it's got to be crushed. And yet, it seems to persist. And this has baffled, it's challenged military leaders, and it's baffled Congress. And Congress is very much keyed up about this, both in the House and the Senate. And in the Senate, Senator Gillibrand of New York has been on this issue for several years. In the House, Congresswoman Jackie Speer from, I think, Southern California, has been very engaged. They have, with somewhat different emphases, come up with legislative proposals that would take some categories of cases outside of the hands of commanders in terms of deciding what should be prosecuted, and given it to lawyers outside the chain of command. There's a variety of proposals. They haven't gotten through Congress yet, but I think it's likely, particularly with the new administration, that there'll be renewed attention to this. A major issue is, what are you going to take away from the commanders? Are you going to do it by the nature of the offense? Or are you going to do it by some more or less arbitrary determination? Anything where the potential punishment is a year or more, for example, the misdemeanor felony dividing line that we're all familiar with. Is that the proper? So that's a major issue. And I would say watch this space, but I'm confident that Congress will do something. What I hope, however, this is Gene's view on this matter, I hope that sexual assault does not become a self-contained separate military justice system. I think that would be a really absurd outcome. It's supposed to be a uniform system of military justice. The idea of having a separate charging system for a type of crime where most of the victims, not all of the victims, are women is, I think, most ill-advised. If nothing else, it would be inimical to unit cohesion, because it might give people the sense that women were getting a thumb on the scale, special treatment. And I don't think anybody wants that. So that's a downside. It's a major issue, though. If you want to follow up with a specific question, I'd be happy to answer it.
Let's go to some other ones. We had Jonathan Epstein asked about, are there pro bono opportunities on military justice issues? He's a Navy officer who went to law school after leaving active duty.
Right. Well, there are opportunities. I'll mention two. One is the National Institute of Military Justice, which is a private NGO I co-founded with some friends in 1991 that files amicus briefs. It doesn't represent individuals. It's not that kind of organization, but it files amicus briefs. It comments on legislation, tries to monitor developments. So National Institute of Military Justice. While talking about, and the other one, of course, is the Orders Project, and I'd be happy to talk a little bit further about that. That's a current exercise, the purpose of which is to provide a sort of second line of defense or advice for GIs who believe they may have received orders that may be unlawful. And it's gotten some press. I don't know how busy our posse of ex-JAGs is going to be. We've had about 20 ex-JAGs step forward and make themselves available if the need arises. Let's hope that the need doesn't arise, but that's an opportunity for pro bono work. We'll see how things unfold in the next few months. And then I'll just mention two things, since everybody here is tech savvy. If you have a crayon handy, you might want to make a note. The first is that website that I mentioned, the Global Military Justice Reform website, Global Military Justice Reform. It's a blog that I edit that monitors events around the world. It's pretty interesting, I think. And if you wanted to find out what was going on in other countries, there's a lot going on in Canada right now. They are really churning and burning on what to do about their military justice system. It's quite interesting. That's a place to look. And the other one is for US military justice. There's a site called CAFLOG, C-A-A-F as in Foxtrot, LOG.org or .com. I think it'll answer to either. This is focused on US cases and developments, and it's quite interesting. It's the go-to place. So those are two resources.
And we can send some of those out in a follow-up email to everyone who registered today if you didn't get all those websites. Let me read one from Mike Winchester. Mike, do you want to go ahead and ask your question yourself?
Can you hear me okay?
Loud and clear.
Okay, thanks. Hey, so I'm a defense attorney in the Army National Guard, and the most common thing I see are adverse administrative actions, usually a separation action against a soldier.
Right.
A real common scenario is there's an allegation of misconduct that doesn't quite hit the probable cause standard. So they're not going to bring criminal charges, so they just administratively punish the soldier and send him on his way, claiming it's a non-punitive action. The problem I see is there's very limited review of these decisions. The commanders have very broad discretion. And as a JAG, I would like to set these guys up so that they could have whatever civil remedies are available and properly preserved. Problem is I don't get a lot of JAG training on how to do that. So I'm wondering if there's a network or publications or somebody I could.
Right. There's no particular network
out to during this administrative process.
Right. There's no particular.
Sorry, I didn't hear that.
There's no particular network. There are many lawyers who represent GIs, private lawyers who represent GIs, but some of them are fabulous. Some of them are less gifted. It's a difficult field. It's a difficult field because to be effective in it, you would have to know not only military justice, you'd have to know the internal administrative law of each branch of the service. And they do vary a little bit from, maybe more than a little bit from service to service. Then you'd have to know federal litigation, both district court type litigation, because these cases are subject to review under the APA, as well as review under the Tucker Act at the Court of Federal Claims. So, you know, to really be any good at this stuff, you'd have to be like a one-man band. You'd have to know a variety of different subjects. There are people out there who do this work. It can be very challenging. Most GIs, even fairly senior officers, can't afford too much lawyering. So unless it's you know, the rare case, or it's a pro bono matter, a lot of these people are not going to be able to invoke the remedies that in theory are available through the federal courts. There's also, of course, the record correction process and the discharge review board process. Again, military lawyers, you know, serving officers cannot take cases to the correction boards, I believe. So you want outside counsel for that. But again, that's a somewhat specialized area. And it's unfortunate that there isn't an organization that really pulls those skills together. Many law schools now have clinics that will do VA cases, and maybe they'll do a correction board case. But I don't know of any that make a regular practice of going into court to get judicial review of an officer's failure of selection leading to, you know, being involuntarily retired or separated from active duty. It is a problem. These cases, by the way, are litigable. I mean, my late friend Kevin Barry, who retired from the Coast Guard as an 06, used to say, scratch a case and find an outrage. And he was a pretty solid citizen. He served 30 years on active duty. So he was not by any means a bomb thrower, but he had a very good sniffer for injustice. And as often as not, if you really dug into a case, you could find something that you could plausibly put in front of a federal district judge and see if you were going to get traction. So that's not maybe the answer that we'd all like to hear, but that's the way it is right now. It's catch as catch can.
Thank you very much.
Sir.
A couple questions in the chat about the general questions about how do you address the tension between the need for discipline and the need to follow orders with questioning their legality. Right.
Well, this has to do with the Orders Project, which is quite an interesting exercise. Maybe can I share the screen? Is that permissible? Can I do that? Do I have authority to do that? Let me see. Yeah. So can you see this? Can you all see this document that I put up? Yes, no, somebody?
Yes.
So this is, okay, great. This is the text of the sort of forward to the source book that the Orders Project has generated. The source book is the teaching materials that we used for training volunteer lawyers, people who were ex-JAGs who were willing to accept calls from GIs if the need arose. And this was not casually written. If you take a minute, if it's legible on your screen, you'll see that we're really careful about this. First of all, any GI that has a question, actually, let me go all the way back. If you look at the UCMJ's disobedience provisions, you'll see that all of them require obedience only to lawful orders. In other words, it's not something that's been pulled out of the air. For many, many years, I think since the 19th century, the statute has, first the Articles of War and now this, the statute has penalized disobedience of unlawful orders. So it's kind of baked into the whole dispute, whole current debate. Most orders are lawful. Orders are presumed to be lawful. We all know this. And it's obviously taking a substantial risk to disobey an order because you think it may be unlawful. And some orders, you know, it's easy around the edges to say, well, look, if you're telling me to shoot women and children in a rice paddy, I'm thinking here of Lieutenant Calley's case from the My Lai massacre. That's a no-brainer. But, you know, I'll give you an illustration that it's kind of a lighthearted illustration, but, you know, makes the point. Suppose you were a member of the Marine band, right? You play the piccolo in the Marine band. I hope nobody's a piccolo player. And the bandmaster says, actually, we're going to play at a rally. The rally's a political rally. Well, is that a lawful order? Suppose the piccolo player's, you know, married to a lawyer, and he or she comes home and says to the spouse, I got these orders to play the piccolo at a political rally. Do I have to do that? And the answer is probably not, because an order can't have for its sole purpose a function that is not a military matter. Now, would you make a fight over something like that? I would say no, of course not. That's ridiculous. The question is, what about the situations that are between those two poles? One issue that came up, as you know, readers of the Washington Post will recall, is the use of helicopters to disperse demonstrators in June, I think. Well, that's under investigation. Who knows what that investigation is going to show? I don't want to prejudge it, but would that order have been lawful if that was the order? Use your helicopter to create prop wash to force, let's say, peaceful demonstrators, assuming they were peaceful demonstrators. Who knows? Anyway, you can see how there really is a spectrum. Most orders, you know, I think you are taking a substantial risk. Anyone is taking a substantial risk who violates an order. And how much do you want to bet that you're right or wrong on that? Not very much, I would say. Anyway, if you look at what we've written here, if you look at the next to last paragraph, we say, in a democratic society, military personnel should always conduct themselves scrupulously and in accordance with the law, and should recognize that disobedience, like civil disobedience, may lead to significant penalties and career injury. That's a fact. The hope is that anybody in uniform who has a serious question about the lawfulness of something that he or she is being directed to do should consult a military lawyer, whether that's somebody from the active component or a reserve component, National Guard, doesn't matter. That should be your first call if you have a genuine issue. If, however, you can't reach such a person, or the unit says, we only advise people after you've been charged, for example. I've heard that said. Or you're not entitled to legal assistance on a criminal matter. Or you simply can't get through to anybody. Well, at that point, we would entertain a phone call and connect the individual with some lawyer who was familiar with military justice. By the way, the training materials that you'll find on the website that I'm screening here are all from Charlottesville. They're the Army's official training materials, and they're, as far as I know, quite an accurate statement of the applicable law. It would take a former military person, you know, maybe 45 minutes to brush up on this stuff. Next question.
I have a couple if you can entertain them.
Sure, I'll try.
Well, the first, I suspect it's one of the intractable problems that you've discussed, and I suspect I know where you stand with regard to it being handled by the military versus civilian recourse, and that is the longstanding problem of spousal abuse in the military. And the reason I ask this is that I covered I don't know if anybody remembers a triple murder suicide down at Fort Bragg in, I want to say, 2003. And there was some question then about what the role of the chaplaincy was, but no real delving into what the legal ramifications are and what the military considers itself responsible for. I suspect that the military has to be more involved on overseas postings rather than domestic ones. But I'm interested in your thoughts on that matter. And although I will readily admit that it's more of a political question than a legal one, I'm interested in your thoughts as to the environment in which scuttlebutt is that one of our top military leaders was relieved of his post partially because of his refusal to order troops to march on legal protesters. So, but anything that you care to posit on either one of those, I'd be very, very interested in hearing. Thank you.
Well, yeah, there's a whole lot boiling around in that. On spousal abuse, this is entirely a personal judgment, and it's in its way, it's a political or policy judgment. This is just Eugene Fidell speaking. I do have a concern that the military, that we've taken somewhat too seriously the notion that the military is a separate society. I think for some purposes, the military is on a different ice flow. I get it. And I do have a concern that at times that ice flow seems to be drifting a little further from the mainland than I would prefer. I don't really think, particularly in the United States, that the military's job is to deal with spousal abuse. I think that's the work of community authorities. That's where the social workers are. That's where they should be. Domestic relations are classically a state law responsibility in our country. So, you know, personally, I'm sort of hostile to the federal government through the military getting involved in something that really, as a matter of federalism, belongs in state hands. So that's my reaction on one level.
And that's where I suspected that you would come down, and it's entirely supportable.
Yeah.
The issue there is access, because in fact, a base is a closed community. And that's the only thing that I'd ask you to consider with that. But I appreciate your thoughts, and especially domestically, it's given the workload of the average GI, let alone further on up the chain, it is hard to justify putting more on their plate. We ended up as a department, this was at the New York Post, we ended up as a department coming down saying that it was a readiness issue. And I think it is. But I hear what you're saying, and I appreciate what you're saying.
Yeah, I mean, I don't think there's a school solution. I will say this. My impression is that fewer and fewer GIs who are married live on the installation. Government increasingly has leased housing outside the gate. And, you know, there shouldn't be a problem of access by civilian authorities. You mentioned chaplains. Yes, was that part of your?
Yes, the chaplaincy as an unofficial channel for dealing with such issues.
Yeah.
I've got a GI in the family And I think that particularly overseas, they were utilized extensively in issues like that.
Right. So, excuse me, I want to make a few comments about the chaplaincy because it's quite interesting. I won't say this is understudied. It's been studied extensively and also litigated. Chaplains are very litigious. Chaplains often see matters of principle where regular people don't. It's the way it is. The chaplaincy has become very problematic, and it's been going through a number of challenges. One is that historically, the sort of array of the American population was easier to gauge. For example, the Navy had a rule; they had a policy of 1/3. So that 1/3 of the chaplains were Catholic chaplains. 1/3 of the chaplains were, I think, liturgical. I think high church Protestant, and the remaining third was everybody else. And that after a certain point became unsustainable. Why is that? Because the increasing diversity within the American religious scene. I mean, there's a million different faith groups. How you decide what's a bona fide faith group is a question in itself. I mean, it raises all kinds of Establishment Clause issues. But figure we've got that solved. But to me, the most interesting thing, and I spoke a couple of years ago to the BU School of Theology, Boston University School of Theology. They were having a program of military chaplains. It was quite interesting. And in my comments, I said, one thing that's going on is a tremendous upsurge in that part of the Christian community for which witnessing, outreach, preaching to the unchurched, fishing for souls is a major mitzvah. And that creates stresses that the classical model wasn't really equipped to deal with. The second thing is this. I think the chaplaincy as such is under some pressure. The classical model is under some pressure because of the growing fervor, the already grown fervor in the evangelical part of the spectrum. And why is that? Because it's my impression, at least, and I hope someone will correct me if I'm under a misimpression here, but my impression, at least, is that lay involvement plays a much greater role in that part of the religious America than in other parts where clergy are the dominant driving force. It may vary from congregation to congregation and faith group to faith group, but I believe the uptick in fervor and activity in a portion of the population, including the military population, where there's great religious fervor, but the fervor is of a lay nature, presents an institutional threat to the chaplaincy. And finally, just on the question of the role of chaplains, it's a very interesting issue. Everybody here has probably heard the phrase mission creep. I think there is a phenomenon of mission creep with regard to reliance on chaplains. I think chaplains are asked to perform services basically because they're gifted in important ways and are used to dealing with people and human HR kinds of issues. But commanders may be relying on chaplains in ways that the founding fathers of this country would not have recognized or approved. I don't think I'm wrong on that, but if I am, I'm happy to hear it. Just a thought. We're just scratching the surface on some of these issues. Next question.
This is one of the ones that was submitted in advance. Gary Lawson is asking about the applicability of Article 88 to retired officers who use contemptuous words against the president. Why has there been no action against these retired general officers speaking contemptuously about the president?
Everybody knows that Article 88 makes it a crime to speak contemptuously of the president, vice president, I think either House of Congress, the governor of the state in which you have are serving, and so forth. There are very, very few Article 88 prosecutions. It does have some First Amendment overtones, although I think at the end of the, it's been upheld by the Supreme Court, and at the end of the day, probably everybody on this call, myself included, would see Article 88 as a constitutional restraint on free speech. So what about these senior officers? We certainly gotten rid of senior officers. There was the fellow who badmouthed President Clinton. I think he called him a womanizer at a banquet in Belgium. For that, he was, I guess, invited to retire. So how to deal with conduct like that by a senior officer? It would seem to me that, if I were Secretary of the Air Force and such a situation came up, the last thing you would want to do is create a martyr. Really, the challenge from a management perspective is to shut down that case right away, quick, and get rid of the individual. And you don't want another Billy Mitchell who's going to try, put the president of the United States on trial in a court martial. So, that's the way these things have been resolved. I'll tell you a story. There was a case in the Kennedy administration in which, and this involved an enlisted man. It wasn't an officer, so it wasn't technically under Article 88, but there was an enlisted man, a reservist in Massachusetts, who said something very nasty about President Kennedy. I think when he called up the reserves, maybe for something in Berlin. I'm a little rusty on what the particular context was, but he'd called up the reserves, and this GI said, well, this is just the Kennedys again, trying to use the army for political purposes, something like that. And it became a big stink. And President Kennedy did hold regular press conferences. And at one of these press conferences, some reporter got the floor and said, Mr. President, what about this soldier in Massachusetts who's under charges? Because they had charged the kid with something. And Kennedy said, and it was early Easter. Kennedy said that he had occasion to consult with the Secretary of the Army, a man named Elvis Starr, I think at the time. And he and Secretary Starr had agreed that in light of the holiday season, there really wasn't a need to bring down the full force of the law on this GI. And that was the end of that. So, sometimes discretion is the better part of valor.
David Pius had a question about the military correction system. David, if you're still on, you can unmute and ask that.
Good afternoon. So I'm a former prosecutor, state prosecutor, and I'm curious what you were saying about the military corrections system. It sounded like you were saying that civilian courts don't want to get involved, but neither do military courts. So what is the avenue for a prisoner, an inmate in the military correction system for access to the courts?
Well, what I was referring to is not access in the sense that, if you have a complaint, you can bring a habeas corpus. If you feel you're in custody wrongly. What I'm talking about is conditions of confinement, really.
And that's what I meant. That's what I
Yeah,
thought you
yeah,
meant.
right, okay. The military appellate courts construe their jurisdiction very narrowly. They do not have general federal question jurisdiction. Their only power is to adjudicate convictions and sentences. So you could come to them with an Eighth Amendment claim based on conditions of confinement, and they'll point you to the courthouse in Topeka. They're just not going to hear the case. The only way it comes up, the only way confinement conditions come up is if you have, for example, mistreatment in a correctional facility for which you're entitled to some kind of credit against your sentence. So that's part of the criminal appellate process. But in terms of attacking the conditions of confinement or programs, the military courts won't do it. You can try with the federal district court, but that's going to be as hard as it is to bring a conditions of confinement case relating to a state penitentiary.
Well, so if an inmate has a complaint about their law library is inadequate, so they can't properly prepare their own appeal. In Florida, you file a case with the local courts, and it can work its way up to the Florida Supreme Court. So
Right.
what does a federal, someone in Fort Leavenworth do if they want to do their own appeal?
I'm smiling because I had
see
a wonderful,
you are.
I had a wonderful case like this. I was representing a guy. It's a published case, so I can mention the name. The case is Sills against Bureau of Prisons. Sills was a Navy, I think he was a chief who had been transferred out of Leavenworth into the Federal Bureau of Prisons. He was in a civilian lockup on a court-martial conviction. I forget what the offense was. And this was during the era of Bounds against Smith, which is a US Supreme Court case that I know you're familiar with. Sills's complaint was that he was confined in a facility where the law library didn't have the military justice books. And in Bounds against Smith, the Supreme Court had said, look, you're entitled either to the books or to a paralegal, basically, who can help you. He didn't have either. And so the question was whether Sills had a right to a set of the old CMR volumes, the court-martial reports. So I filed a case for him in federal district court in Washington. And we drew it was a informa pauperis case. And we drew the judge who did all the pro se cases. I forget who it was at the time. He was kind of a mean guy. I think that's who they gave those cases to. Anyway, this judge, I think it was Judge Gash, instead of letting the case proceed, and it was a perfectly good complaint. I mean, it's a pretty straight complaint. Judge Gash wrote on the title page. He just hand wrote on the page 1 of the complaint. Denied. There is no right to the equivalent of Widener Library. Widener Library being the main undergraduate library at Harvard College. And that was it. The case was over. And I took it up to the DC Circuit, and the DC said, this is the rare case where you could get the DC Circuit worked up enough to summarily reverse. And they did, I think Abner Mikva was on the panel, and they summarily reversed. And in doing so, the first paragraph quoted Judge Gash's line about Widener Library. We ended up on remand, settling it with the US Attorney's Office, and I think or with Maine Justice. And I think for 5 years, there was a program where any Bureau of Prisons facility that housed military prisoners would have a set of the military law books. I think that it ultimately faded. I think there are very few such prisoners today. But you know, you can get these things into federal court, and occasionally you have some fun with them.
Joel Posnetsky has a question. Could you tell us whether there are significant differences between the cases involving the 3 pardoned by the president for war crimes? Press has largely lumped them together.
Yeah, the press has lumped them together. It's understandable. Well, in one case at least, this is the case of Lieutenant Goldstein. He had not yet been convicted. So that's somewhat separates him. In the others, they had been convicted. And of course, there's the case of Chief Gallagher, the Navy SEAL. Chief Gallagher had been acquitted of a homicide. So he didn't have a conviction for a significant war crime. There was I think he was convicted of taking an improper photo with the body of an enemy combatant, which I would call a minor war crime. So, but it doesn't really count, and that went away anyway. I mean, that case just collapsed because of a variety of factors. But it is true, and this unfortunately is a shortcoming of journalism. Fewer and fewer journalists have personal familiarity with the administration of justice within the military. And if I can use a Coast Guard expression, sometimes journalists will cut the buoys. In other words, they'll take the easy way instead of, you know, being more precise or lawyer-like about things that are actually quite complicated. And I think that some of that happened in the coverage on the president's pardons. I think the pardons were, you know, I'll say it, quite unfortunate and disturbing, actually. The things that those people did, I'm not going to say whether they were guilty legally or not. They've been pardoned or given clemency. Were certainly reprehensible, and they do erode our credibility overseas. It's a problem. Some years ago, the DOD General Counsel, at the time it was Jay Johnson, who went on to be the Secretary of Homeland Security. But when he was General Counsel of the Pentagon, he created something called the Defense Legal Policy Board. And I was on that board. And one of the things we studied was how the Pentagon or the military, I should quickly say the Pentagon itself has precious little to do with military justice. The military justice is actually quite decentralized. The services are quite autonomous when it comes to military justice. But anyway, the Defense Legal Policy Board did a study of how the government deals with war crimes. And there was one piece of information that I have always kept in mind. They did surveys of Army soldiers and Marines. And the numbers of the percentage of GIs and Marines who would not put a fellow member on report for a war crime was much higher than I would have thought. It was like 40 or 50%. For one service, it was 40% wouldn't put you on report. For the other service, it was 50%, and I don't remember which was which. Wouldn't put a fellow soldier on report. I don't know how to get around that, but it certainly, it can't be right. And it's a failure of instruction and training, because investigation is a duty of commanders. We have our commanders, all commanders have a duty under the law of armed conflict to investigate potential war crimes. And you can't investigate a potential war crime that you never find out about. So that's a real problem.
We have Josh Slomick has a question. Could you update on status of Gitmo military commissions and whether you think there will ever be a verdict in 9/11 case?
Oh, well, there are still a few people on trial. The 9/11 perpetrators are on trial. Personally, I think it's a scandal how those proceedings have been conducted. I think administration after administration blundered by insisting on using the military commission mechanism. That was a miscue at the very beginning. I think the W administration wanted to make a point, and it was a horrible blunder. A second horrible blunder came under President Obama when there was a short moment when Attorney General Holder threatened to move the commissions out of Guantanamo and into the Southern District of New York. And I'll just take a second to go down memory lane. Why did that fall apart? It fell apart because nobody had cleared it with Mayor Bloomberg. And when word of this proposal got out, the head of the local, I think, community board, it's like the ANCs in the Washington area, local community board for Lower Manhattan, went ballistic and got all spun up. The New York Police Department claimed it would cost $800 million to provide security. That I think is ridiculous, but that's what it was. And the mayor said, "I don't want this." Whereupon the Obama administration faded and the process continued at Guantanamo. I think it's terribly unfair. I don't really care about the accused. I care about the families. I think the families of people who were murdered on 9/11 deserve closure, and they've deserved it for a long time, and they're not getting it. And I think it's just a disgrace. Now, how are those cases going to unfold? I have no idea because of continuing miscues. One of the judges got fired by the DC Circuit by a mandamus last year because he'd been secretly negotiating for a position as an immigration judge. Didn't tell anyone about that. And that set back that prosecution. I think that was in the USS Cole bombing case, the Nashiri case, set that back years. And they keep on, the judges keep on retiring on them or just saying, "I've had enough." The judges don't live at Guantanamo. So, and when the Defense Department told them, "Look, stay in Guantanamo until these cases are done," the judges staged a mutiny. So this really is a busted system. I'd love to be in charge of it because I'll tell you, there's got to be a way to do this better, probably in a different form. And I hope it's not too late for that.
We had a question from Nelson Melitz early on. If you've seen any increase in cases or situations related to anti-Semitism in the military?
No. No.
A couple questions related to the legalization of cannabis in civilian law and how that is going to work its way into military law, especially connected to PTSD and traumatic brain injury.
Well, I haven't heard anything about relaxing the rule for military PTSD personnel. I mean, the only way that could come up, I'm just thinking as a disciplinary matter, would be if you had somebody in the temporary disabled retired list, the TDRL, who had PTSD and had to resort to marijuana. The military doesn't go out of its way to prosecute people on the TDRL. So I suppose also, in theory, and this is subject to litigation, by the way, in theory, people who are retired, I mean, permanently retired, are still subject to the code. If you're a retired regular or a retired reserve in some circumstances, you can be subject to the code. Retired reserves, if you're drawing hospitalization, I think that's the catch there. But in theory, you could have a retired regular who had PTSD and could be prosecuted for using marijuana. I know of no such case, and the government very, very rarely prosecutes retirees. It's really got to be a serious case for them to do that. And even then, their power, in my own opinion, I don't think that's a constitutional provision, and that's being litigated right now. Full disclosure, I'm counsel in such a case.
Going back to some of the ones asked earlier on in the chat, you had brought up European courts. Jerry Alperstein asks, how do European courts handle the equivalent of General Article 134?
I can't speak specifically to the European courts. What I can say is that 134 itself, at least part of it, can be found in those systems that are descended from the British Articles of War, the 1774 George III Articles of War. The controversy that's come up in several countries has to do with not whether this is conduct to the prejudice of good order and discipline. That's really the core of the general article. The other parts are conduct that's service discrediting, and I could talk about that. And then the final thing is other crimes and offenses not capital. So on service discrediting, that is Article 134.2, many countries, some countries will prosecute conduct that is like service discrediting conduct. They may call it insulting the flag, insulting the army, stuff like that. I think we could get along perfectly well without an offense of conduct that is service discrediting. I mean, I'll give you an illustration. We prosecute people for pornography on their computers. A case came up in Australia where some soldier was viewing pornography on his Australian Defence Force computer, and he was prosecuted on the theory that this would bring discredit on the service. And the Defence Force Discipline Appeal Tribunal, which is their equivalent of the Court of Appeals for the Armed Forces, said, actually, most people in Australia could care less. Nobody, the fact that some GI is looking at dirty pictures on a computer doesn't, in fact, detract from the high regard that Americans have for the military in any event. So I think we could just get rid of that provision. If I were king, I'd probably be tempted to just strike that from the manual for courts martial. Now, the interesting question is, and many countries have sort of catch-all provisions that say, other conduct to the prejudice of good order and discipline. It picks up, the sailor who wears black socks instead of white socks or whatever, all this crazy stuff, or the people who jump off ships underway on a bet. That's the Sedinsky case that many of people on this call may remember. Where there has been litigation in other countries is the provision that's like Article 134.3, which is the one that picks up any offense under general criminal law. And this came recently to the Supreme Court of Canada, for example. Like 2 years ago, there was a major case. They have such a provision. Australia also has such a provision that I think was recently upheld. It does seem to me, and the theory in Canada was, look, if I commit some offense downtown, That's an offense under the Canadian Criminal Code, which is the federal law. I have a right to a jury trial, and that's protected by the Canadian Charter of Rights and Freedoms. But if you take that case and treat it as a service offense, my right to a jury trial goes out the window. And so that was a challenge under the Canadian Charter that went to the Supreme Court of Canada. The court split, I think, 5-2. I'll say the wrong way. I think the right to a jury trial, a good old-fashioned jury trial, is invaluable. And I think if something can be prosecuted downtown, that's where it should be prosecuted instead of sweeping it in under some catch-all provision. So that's kind of an answer to the question, maybe.
Joel Tosnetsky is asking for an update on the Vineman cases, if that's possible. Could you tell us about them, how you expect them to unfold?
I'm going to pass on that if you don't mind. I'm one of the attorneys representing one of the Vineman brothers. And I think since it's a pending matter, I think I'd prefer not to discuss that if you don't mind.
Sure, sure. I think we have just about addressed all the questions in the chat. So if people just want to jump in for the last few minutes that we have, we're just about out of time, but we could probably get a couple more in. If anyone has more questions or.
Yeah, Gene, I have one. Gary Ginsberg.
Hey.
Concerning the presidential pardons that we talked about a few minutes ago, and I realized the cases were all a little bit different, but particularly where you have convictions of a major war crime, whether it was in that case or hypothetically speaking, does that create future issues with respect to an American soldier Marine that would be taken POW? We would expect the individual to be treated humanely, consistent with, the Geneva Convention and so forth. But if we're doing things, whether it's waterboarding or, again, any form of major war crime, does that put potentially American military personnel in some jeopardy?
It does. It does. I mean, anything we do like that, we're going to have quoted back to us. Other countries, for example, have taken to prosecuting civilians in military courts, which we almost never do. There's a tiny little way we can do it. People serving with or accompanying an armed force in the field in time of a declared war or contingency operation, that they can be prosecuted, and we've done it once or twice. Not a big deal. But when we started doing military commissions, other countries to prosecute civilians, other countries have done the same thing. And they say, wait a minute, the US does it, how can it be wrong? So, in this day and age where, anybody, with $100 can have a computer and an internet connection, you can't keep this stuff secret. People know about it, they seize on it. And these are people who, on a good day are not all that committed to the rule of law. So anytime a decision is made like that, and the pardons are an example, we're likely to hear about it, but with the tables turned on us.
Right. Thank you.
Well, with that, thank everybody for being on. Thank Gene for your time, your expertise, your insight. And let's see, Nelson Meltz has one more. Is there double jeopardy where a military member is found innocent civilian in a court martial, and can the member still be tried in a civilian court?
That's a quickie. The answer is, under the prevailing notion in the US, there's a doctrine called separate sovereignty, so that if you're acquitted or convicted in a state system, for example, the federal government can still try you, and vice versa. Some states decline to exercise that power. Virginia has a statute, for example, that prevents it. But from time to time, you will see people who are acquitted in one jurisdiction, and then the authorities will hold hands and pass off all the evidence and try the individual again. It rubs people the wrong way, but it does seem to be constitutional. The one thing that you can be sure of is you can't be prosecuted both in a court martial and in federal district court in situations where the same conduct might trigger a problem under Title 18 as well as under Title 10, because that's the same sovereign. Courts martial are prosecuted in the name of the United States.
All right, so that's a great place to end. Thank you so much, Gene. Thank you, everybody, for being on, and we'll see everybody next time.
Thank you.
Thank you.
Nice to see you all.
Thank you.
Yes, thank you.
Appreciated it.
Thank you.
Thank you.